Good day everyone. My name is Cristal B. De La Torre and with me are my group mates, namely Lilian Aminoso, Cristina Balatayo, JB Borlado, and Nika Otukan.
So we are the Group 3 reporters and we will discuss the Chapter 4 rules governing import and export of goods. So in a business operation in general and international business in particular, the sales of goods are key transactions. On the domestic scale, it is the exchange of goods within that country, while on the international sales, it is the exchange of goods among different countries through the import and export transaction. So we have a 10 key clauses of an international sales contract. The first one is description of goods. The second one is contract price. The third one is delivery terms. And fourth one is time of delivery. Next is payment condition, documents, inspectation of goods by the buyer, retention of title, force majeure, a resolution of disputes. So 4.1 Regulation on international sales of goods. There are many different sources of law that govern the international sales of goods, of which the three main sources are domestic law, international treaties, and international mercantile custom and usage. So we will discuss it in the next slide. The first main sources are domestic law. So each country has its own set of laws that regulate international sales. So these laws can be statutory. In the case where the laws of this country comprise different rules on the same issue under this part, it may cause a conflict law, for example, on the contract form or the content of contract. So, bawat bansa ay mayroong set of regulation governing international sales. So, ang international sales, ito yung nakikipag-import and export sa iba't ibang bansa. So, this law can be statutory or may include a regulation of contracts, warranties, product liability, and dispute resolutions. So, in the cases where the laws of different countries involved and transaction have been conflicting rules on the same issues, so it can lead to a conflict of law situation. In order to resolve conflict law, the best way for parties to agree to choose a national law applied to their contract. So the 1987 Constitution provides rules for resolving conflicts on the legal status of a foreign natural persons, foreign legal persons, and conflicts on contractual liability. Besides, the rules of conflict are also stated in the other regulations such as law on investment, or it is a branch of law consisting of set of rules that regulate investment, maritime code, acts provide rules for maritime and navigations and relative to the nationality of ships, its property and other rights in respect of ships. Then, commercial law, also known as mercantile law or trade law. So, some countries choose to issue a separate private international law code, such as the Polish Private International Law Code in 1965 governing civil relation, marriage and family and labor, and the Belgian Private International Law Code 2004. So, in 1987 Constitution, ito yung nagbibigay gabay para maresolbahan ang alitan ng bawat bansa. Ang Constitution na ito ay naglilingkod bilang pinakamataas na batas at binibigyan diin ng pahayag ang kahalagahan ng pagkakaroon ng isang prohensibong legal na sistema. International treaties. So, conflict of laws may cause disputes in international sales of goods. To prevent these, countries often negotiate the adoption of related international treaties in order to unify certain rules aiming to governing this transaction. So, there are two types of international treaties. The first one is to unify the substantive rules, and the second one is to unify the rules of conflict. So these treaties may be either bilateral or multilateral. So bilateral, this involves agreement between two countries to cooperate on specific issue or goals. while the multilateral agreement, so this involves agreement between multiple countries, often facilitated by international organizations to address common issue or achieve shared objectives. Let's first discuss the treaties to unify the substantive rules. The unification of the substantive rules occurs when the countries agree to create the substantive rules in order to govern international sales of goods transactions. So there are several important international treaties in the field of international sales of goods. Nowadays, countries that joined the Vienna Convention 1980 have already declared the abandonment of these two conventions. The Vienna Convention 1980, the United Nations Convention on Contracts for International Sales of Goods. At first, so ang substantive rules, it is the essence of law, or ito yung create rights and atong right created by legislature. So the CISG ay tinanggap sa Vienna noong April 11, 1980 and officially came into effect on January 1, 1988. O dito na nagsimula magkaroon ng visa. So the CISG was drafted by the United Nations Commission on International Trade Law or UNICITRAL in an effort to create a uniform legal document for substantive rules in the international sales contract. So the CISG has the stronger influence on the international sales of goods. As August 1, 2011, ang UNICITRAL nireport ang 77 estado na nag-adapt upang pamalaan ang 34 na kanilang international sa kalakalan. One is treaties to unify the rules of conflict. So the national rules of conflicts may differ among countries. If there exist different national rules of conflict to resolve the same issue, they might occur the conflict of rules of conflict. So the uniform rules of conflict may be specified in bilateral or multilateral. The bilateral treaties related to this issue are mutual legal assistance agreement before 1990s. So when the Soviet Union and the former East European socialist countries still existed, Philippines adopted mutual legal assistance agreements with the countries such as the German Democratic Republic, the Soviet Union, and Czechoslovakia, Cuba, Hungary, and Bulgaria in 1987 after the new Filipino Constitution. So, the country adopted 9 more mutual legal assistance. So, the multilateral international agreements to unify the rules of conflict were usually adopted within the framework of an international organizations, the most important of which was the huge Conference of Private International Law. So applying rules of conflict therefore causes considerable difficulties and risks in resolving the conflicts of law. One example of an agreement to harmonize conflict rules is the United Nations Convention on Contract for the International Sales of Goods, or the CISG. So this is an international agreement aimed to providing an in general framework for contracts for the international sales of goods. So through the CISG, countries seek to establish a consistent set of rules for international sales of contract, facilitating business parties to navigate discrepancies between the laws of international countries. So according to this agreement, the rules of conflict were uniformly applied to the member of the countries. For example, the rules to identify the law applicable to foreign relation relating to civil matters, and the rules to identify the competent jurisdiction. So these rules related to marriage, family, and heritage relation, but not international commercial transaction. So the Youth Conference is a permanent institution responsible for the unification of private international law on the global scale 16. So atong conference ay nag-compile at nag-adapt ng maraming international kasunduan na nagpalawak at nagpatupad ng malaking halaga na paglutas sa mga alitan ng international sales. Let's first discuss the treaties to unify the substantive rules. The unification of the substantive rules occurs when the countries agree to create the substantive rules in order to govern international sales of goods transactions. So there are several important international treaties in the field of international sales of goods. Nowadays, countries that joined the Vienna Convention 1980 have already declared the abandonment of these two conventions. The Vienna Convention 1980, the United Nations Convention on Contracts for International Sales of Goods. So, ang substantive rules, it is the essence of law, or ito yung create rights and atong right created by legislature. So, the CISG ay tinanggap sa Vienna noong April 11, 1980 and officially came into effect on January 1, 1988. O dito na nagsimula magkaroon ng visa. So, the CISG was drafted by the United Nations Commission on International Trade Law or UNICITRAL in an effort to create a uniform legal document for substantive rules in the international sales contract. So the CISG has the stronger influence on the international sales of goods. As August 1, 2011, ang UNICITRAL nireport ang 77 estado na nag-adapt upang pamalaan ang 34 ng kanilang international sa kalakalan. International Mercantile Custom and Usage. So, international mercantile custom and usage are an important source of law governing sales of contracts. So, they have been recognized and widely applied to business activities on a regional and global scales. So, this usage or custom are essentially established practices and norms within the international business community that have gained recognition and acceptance over time. So they are served as supplementary source of law alongside formal legal framework such as national laws and international conventions. So statutory choice of law. So this table represents these different statutory choices of law in international transaction categorized into different types. So the huge International Sales Convention. So this convention provides rules for international sales contracts involving movable goods. So it was established in 1955 and aims to harmonize international trade law concerning the sales of goods. So, the United Nations Convention on Contracts for International Sales of Goods. So, the CISG is a widely adopted treaty governing contracts for the international sales of goods, and it is established a uniform framework for the promotion and performance of such contracts, promoting efficiencies and certainty in international trade. So lastly, the Rome Convention on the law applicable to contractual obligations. So this convention addresses the issue of determining the applicable law for contractual obligations in international transaction. So it was established in 1980 and provides rules for resolving conflicts of law in contractual matters. So, statutory International Mercantile Custom and Usage. So, international mercantile custom and usage are an important source of law governing sales of contracts. So, they have been recognized and widely applied to business activities on a regional and global scales. So, this usage or custom are essentially established practices and norms within the international business community that have gained recognition and acceptance over time. So they are served as supplementary source of law alongside formal legal framework such as national laws and international conventions. Lastly, other legal sources. So the model contracts and general principles of contract law are other sources of law, so which are also becoming increasingly important in governing international commercial contracts in general and sales contract in particular, having legal effect similar to international mercantile custom and usage. So firstly, regarding the model contract, it is necessary to distinguish a model contract drafted by the professional association from one provided to the parties but very common. So secondly, regarding the general principles of contract law, they have been usually extracted from international business practices, recognized and applied the traders in their international contracts, transaction and have considered popular. So firstly, regarding the model contract, it is necessary to distinguish a model contract drafted by the professional association from one provided to the parties but very common. So secondly, regarding the general principles of contract law, they have been usually extracted from international business practices, recognized and applied the traders in their international contracts, transaction and have considered popular.
Incoterms. The most widely used commercial terms are those published by the ICC known as Incoterms. They are applied throughout the world and their use in international sales is encouraged by trade council, courts, and international lawyers. First published in 1936, the current version is Incoterms 2010. The 2000 revision made few changes from the previous revision. Incoterms 1990. The 1990 revision made several significant modifications to the earlier terms, reflecting changes both in technology and shipping practices that occurred during the 1980s. The ICC Incoterms, possibly the most complete of such as rules, are lengthy and deserve carefully study. Parties are made free to make addition to or vary meaning of any particular term, provided that such addition or variation do not conflict with the nature of the terms. So, Incoterms known as international commercial terms for sales, international sales of goods and services. The CISG was drafted by the United Nations Commission on International Trade Law hereinafter the unilateral and adopted in Vienna in 1980. So the CISG now gained worldwide acceptance and is considered to be the most successful convention promoting international commerce since its entry into force on 1 January 1980. As of August 1, 2011, UNICETRA reported that 77 states have adopted the CISG. So the CISG is a treaty that provides a uniform regime for contracts for the international sales of goods. So the purpose of CISG is to provide a modern, uniform, and fair regime for contracts for international sales of goods. Thus, the CISG contribute significantly to introducing certainty commercial exchange and decreasing transaction costs. The CISG includes 101 articles is divided into 4 parts. The Part 1 is laid down rules on its application and general provision. The Part 2 governs the formulation of the correct. The Part 3 is contains the substantive rules for the parties, sales contract, example, the obligation and rights in particular remedies. The Part 4 is contain rules on ratification and entity into force including the reservation. So, the criterion for identifying an international sales contract according to the CISG. So, a contract is considered as an international sales contract if the parties to the contract have their respective places of business in different countries, which are the contracting states, or the rules of private international law lay to the application of the law of a contracting states. Though the CISG governs international sales contract if both parties are located in contracting states, or private international law lays application of the law of a contracting states, all taught as permitted by the CISG in Article 95. Several contracting states have declared that they have bound by the latter. Pair of CISG application, the two cases of application. Firstly, it is the case where there is a choice of law referring to apply the CISG. Secondly, it is the case where parties to the contract do not expressly or implied identify the applicable law as a CISG in the contract. So in this case, a CISG will be applied. In a jurisdiction where the anatomy of the party is respected, parties to the contract may fairly identify the CISG to be governing rules on their contract. And the secondly is the CISG at this event will be applied under the Article 1. If no private international law rules apply, the CISG would be governing law. Where private international laws refer to the law of a contracting state, the applicable law would be the CISG. Formation of international sales contract. Under the CISG, an international sales contract comes into effect when the acceptance of an offer becomes effective in accordance with the provision of convention. So the number one is the offer. An offer is definite expression to the offeror's will intention to be bound. Addressed to the one or more specific person, a proposal that is not addressed to one or more identified person would be considered as an offer if this is clearly indicated by the person making an offer. An offer is a proposal made by one person to another person. It is the first step for making a contract, and it has to be sufficiently definite and should represent the intention of the person making the offer. An offer is a clear proposal to sell or buy a specific product or service under the specific condition. Offers are made in the manner that a reasonable person would understand acceptance and will result in a binding contract. Acceptance. By accepting the offer indicates his assent to the offer. As soon as the indication of assent reaches the offeror, the acceptance becomes effective and a contract is formed. Action of the acceptor, such as the dispatch of goods or payment of the price, may indicate an implied acceptance. So acceptance is a declaration of intent by the offeree which, in order to conclude an effective contract, has to be communicated by the offeror. Obligations of the seller. The seller must deliver goods that confront and are free of third-party rights. Delivery is the physical handover of goods to the buyer. If nothing has been negotiated about the place of delivery, the seller must, in principle, to make the goods available at the place of where he has the place of a business at the time of concluding the contract. The seller should deliver on the date agreed in the contract or implied by the contract. If nothing is fixed for the delivery date, then the principle of reasonableness applies. So, the delivered goods must be conformable. The conformity of the goods means that goods must be of the quality, quantity, and the description required by the contract and are packaged in a manner required by the contract or a sales sample. Obligations of the buyer. The buyer must take delivery of the goods. Taking delivery is indelibly linked to the passing of the risk. The buyer must do all of that can reasonably be expected of him or her in order to make delivery possible. So the buyer must actually take possession of the goods. In principle, the risk passes at the taking delivery of the goods. If the buyer does not take delivery, she would breach the contract, which make him or her liable for damage to the work. So remedies for breach of international sales contract. In the process of implementing the sales international contract, if the breach of contract is committed by the breaching party, the other party can apply the agreed remedies in the contract or as laid down in the CISG. It is important to note that applying the remedies provided by the CISG depends on whether there is a breach of contract or not. Unfortunately, the CISG did not define what constitutes a breach of contract. However, one can conclude the CISG remedial that breach of contract includes all forms of defective performance as well as complete failure to perform. It is also includes both executable and inexecutable non-performance. The contractual obligation may either be one expressly defined in the CISG example, delivery at the right time and at the right place of the correct of goods, or one created and defined by the parties to the remedies of the buyer. If the seller fails to perform or any of his obligation, the buyer may, depending on the circumstances, resort to or a number of remedies such as specific performance or additional period of performance. So the remedies of the seller. The remedies available to the seller are the same as those available to the buyer. She may also require the performance of an obligation, declare the contract avoided, and claim damages. The required performance of an obligation, declare the contract avoided, and seller may fix additional period of the time for the performance to the buyer obligation, as may the buyer and the seller may suspend the performance of his or her obligation or declare the contract avoided. If it is clear in advance the buyer will not perform his or her obligation. Furthermore, the seller may make the necessary specification when the buyer failed to supply missing specification. The CISG provided equal remedies for both of the buyer and seller. Moreover, the exemption also have been available for them.
For the purpose of PICC, or known as Principles of International Commercial Contracts. First, PICC serve as a guiding framework in contracts where parties have not chosen a governing laws. Second, it supplements international uniform law and domestic law, serving as a model for legislators. And lastly, PICC significantly impacts international contracts by providing clarity and consistency. And for the role of PICC is referenced in contractual relationships submitted to Lex Mercatoria
key
or
clauses of an
international
international
commerce
sales
usages.
contract. The first one is
It also
description of
influences
goods. The
legislative
second one is
reforms
contract
in
price.
various countries
The third one
and
is
is
delivery
adopted
terms.
in model
And
contracts
fourth one
by
is time of
organizations
delivery.
like ICC
Next is
or
payment condition.
WTO.
Documents,
PICC
expectation
evolve?
of goods by the buyer,
PICC
retention
evolved
of
through
title,
editions in
force
1994,
majeure, a resolution of
2004,
disputes.
and 2010, expanding its articles and chapters over time. Its evolution has reshaped the legal landscape and international business practices, ensuring relevance and adaptability. Introducing PECL. PECL, a product of the Commission on European Contract Law, provides a
The
harmonized
first main
framework
sources
for
are
European
domestic law.
contracts.
So each
Its parts
country
and
has its
chapters
own
offer
set of laws that
comprehensive
regulate
guidance on
international sales,
contractual
so
rights
these laws
and
can be
obligations.
statutory. In the
So we
case where
have
the laws
four
are this
principles
country comprise
of
different rules on the
PECL.
same issue under
First,
this spot, it may
application.
cause a conflict law,
PECL
for
applies
example,
in
on the
international
contract
sales
form or
contract,
the content
subject
of
to
contract.
explicit or implicit agreement by the parties. It governs contracts connected to Europe, ensuring consistency and fairness across jurisdictions.
So the 1987 Constitution provides rules for resolving conflicts on the legal status of a foreign natural persons, foreign legal persons, and conflicts on contractual liability. Besides, the rules of conflict are also stated in the other regulations such as law on investment, or it is a branch of law consisting of set of rules that regulate investment, maritime code, acts provide rules for maritime and navigations and relative to the nationality of ships, its property and other rights in respect of ships. Then, commercial law, also known as mercantile law or trade law. So some countries choose to issue a separate private international law code, such as the Polish Private International Law Code in 1965 governing civil relation, marriage and family and labor, and the Belgian Private International Law Code 2004. International treaties. So conflict of laws may cause disputes in international sales of goods. To prevent this, countries often negotiate the adoption of related international treaties in order to unify certain rules aiming to governing this transaction.
So, international mercantile customer and usages. So, to show that the customary practice has become customary law, two elements must be established, one behavioral and one physiological. First is the behavioral element called usus and Latin requires, consisting in recurring action or lack of action if the customer is one of non-involvement by state and other actor. Evidence in such action can be found in comment on draft treatise, nation court decision, and even legislation of subordinate government, etc. Second, the physiological element in showing that customer practice has become law requires that state observing the custom must regard it as binding. That is, they must recognize that the custom as being practiced that they must obligatorily follow and compared with one that they follow out of courtesy to other state. So next is method of financing of international sales of goods. This is a section addressing mainly financing and international trade, especially international sales of goods. Following Article 1 of the CISG, an international sales as contract must be signed by the parties whose place and business are in different states. So here the parties in documentary collection. When payment is to be made by the documentary collection, the parties to the operation are: first is the principal, usually the drawer. So the seller who prepared the collection documents and delivered them to his her bank with collection instruction. And second, the remitting bank. Normally, the seller banks which forward the documents together with the seller instruction to the collection bank. And the third is the collecting bank. So is the bank other than the remitting bank involved in the processing of the collection and would normally be the remitting bank correspondent in the buyer countries. So, next is the presenting bank. So, normally, the buyer bank, which represent the collection of the drawee, buyer, and the collect the payment of obtain the acceptance from the drawee. The collecting and presenting bank are often one of the same bank. And the last is the drawee. The buyer whom the documents are presented by the payment of acceptance. Application of the UCP Article 1 of the UCP provides the Uniform Customer Practice for Documentary Credits in 2007. Revision and ICC Publication Number 600. UCPR rules that apply to any documentary credits including to the extent or to which they may be applicable. Any standby letter of credits when the text of credits expressly indicates that is subject to these rules. So, from the scope of application above, three legal matters should be taken into consideration. First is UCP rules apply to documentary credits. The UCP also apply to the standby letter or credits and practice international commerce, has indicate, however, that it is suited to the type of letter and credits that the trades are unwilling to apply the UCP to standby letter of credits. And the second is apply in the case where the text of the credit expressly indicate that it's a subject to these rules. So, the traders, or more precisely, the parties to commercial contract are free to incorporate all or any of the UCP rules into their contract. Incorporated, the UCP will govern all aspects of documentary credits arrangement except the relationship between the applicant and the beneficiary under the underlying contract between the seller and the buyer. Under seller or sales and contract, as this contract does not usually incorporate the UCP. So, the next is the UCP binding on all parties thereto unless expressly modified or included by the credits. So, when incorporated in the underlying contract, an international sales contract, the UCP will automatically become an integral part of the contract made by reference and all terms and conditions of use of the documentary credits as well as other provision of the UCP will become part of agreement made between the parties. So here the type of documentary credits, revocable and revocable credits. So, revocable credits and irrevocable credits constitutes an definite undertaking by the issuing bank that will be honoring credits providing that there is a complying presentation of the documents specified in their credits. And the revocable credits is a credit that may be cancelled or terms altered at any times without the consent of the beneficiary. Revocable credits therefore afford the beneficiary either no or the lowest level or security protection. So next is unconfirmed credits. Therefore, unconfirmed credits is only issuing bank provide an undertaking to pay the beneficiary although the credits will be advised to the seller by the advising bank. The advising bank has no undertaking to pay. So, confirmation means a definite undertaking of the confirmed bank. In addition to that of a issuing bank to honor or negotiate a complying presentation. The confirmed undertaking may be detailed in the credits advised by the confirmed bank. Otherwise, the use of word "they credits" is unconfirmed by as of similar and sufficient and imply the undertakings specified by the confirmed bank. Confirmed plus irrevocable credits. It's all ideal for a seller obtain an irrevocable credits plus confirmation by a reputable bank in his or own country. which almost serve to provide the assurance that she will get paid. So next is when a credit should be confirmed. When the issuing bank is a well-known first-class bank of high standing, located in a country in a stable political and economic climate, confirmation has little practical value. So next is operation of a credit confirm. The instruction to the advising bank to the confirm a credit must be given by issuing bank, which will be responsible for the confirmation fee unless the instruct that the fee is to change to the beneficiary. So next is a silent confirmation. Silent confirmation falls outside the current provision of the UCP. A silent confirmation is an undertaking given by the bank at the request of the beneficiary without the request of authorization of the issuing bank to add its undertaking to a letter of credits to pay according to the terms of credits, providing all documents are presented in order.
The different payment credits clarified by the time at which the seller entitled to payment. Documentary credits may be divided into the following categories. Payment at sight. The bank undertakes to pay the seller the documentary under the credits upon presentation of the specified documents, and as usually call on the sellers to draw in the side bills of exchange and the present these with supporting documents in under to obtain payment. Different payment. The bank undertakes to pay seller some future date determined in the coordinates with the terms of the credits. 90 days from the shipment, where the future payment by bank is to be made under that against unaccepted bills to exchange acceptance credits. The credits is known as a different payment credits. Acceptance credits, the bank undertakes to accept bills of the change to exchange draw on in by the seller.
Example, ang site payment credits is a document nga ga-rectify sang payment of goods or services. Kag ang acceptance payments credit nga ga-accept sang mga bill of exchange drawn on the issuing bank or ang bank where ang credit is available. Kag ang different payment kag pinaman is 100 by bank kung sa diin himo siya sang promises to pay at a later date.
Straight or special advice credits and negotiation credits. In some credits, known as string credits, that issuing bank payment undertaking is a direct socially toward the seller. In other credits, known as negotiation credits, the issuing bank payment undertaking is not confined to the sellers. It extends to the nominated bank authorized negotiate to purchase and the bills to exchange drew by the seller, drawn on the bank under that the nominated bank and or documents under the complying presentation by advancing or agreeing to advance found to the beneficiary on before the banking day on which a reimbursement is due the nominated bank.
It is non-transferable because it's only allowed para maka-payment sa beneficiary nga naka-name lang sa letter. Ang negotiation means it can be transferred usually to a bank nominated by this beneficiary which will demand payment sa
Number 5, red clause and green clause credits. Red clause credits are those allowing the sellers to draw on the documentary credits in advance of shipment. The types of credits come to be known at the end. Red clause credit signs to close is printed in red length. Green clause credits comes to be used in the coffee trade and dairy and operate similarly to the red clause credits. The only difference is that in these types of credits, the goods are stored in the name of the bank.
Ang red clause credit naman, it is a form nga ga-allow sang importer to pay the exporter sang advance payment. Example, company is the USA contract in India vendor. Once the trade agreement is reached, the importer might contact a bank to provide a dominatory credit. So, ang green clause credit naman, ga-required ini siya sang vendor para mag-provide sang form of guarantees such as a warehouse, receipt, or warrant or evidencing the existence of the products being played in favor of the financial institution. Example, business is buying premium what worth $100 from business B in India. B. Request to issue a green clause C with an advance and payment to $75. $75 value agree and applies for a green clause letter with East Bank.
Number 6, revolving credits. A credits revolving around the value enables the beneficiary to present and documentary as often as she wishes during the credits period, so long as the overall limits specified in the credit is not exceeded.
Revolving credit is referred to an open-ended credit account. It can be used and then paid down repeated by as long as ang account it remains open ka good and standing ini siya. Example, credit card. One of the example of revolving account that can be used by customer.
Number 7, transferable and non-transferable credit. The transferable credits allow the seller, the original beneficiary of the credit, to transfer the rights embodied in the credits to a third party, his own supplier.
Transferable credit always transferred to the secondary beneficiary, and the non-transferable credit he does not allow to transparency the letter of credit to other beneficiaries. Example of transferable credit: exporting and importing goods from another country and to another country.
Number 8, demand guarantees and standby credits. This type of credits are within the UCP. They are, however, of different characters from the ordinary documentary credits are discussed in the next subsection. Operation of documentary credits. These using bank often the irrevocable credits are that its term undertakes of pay the contract price or the incur a different payment undertaking and pay at maturity, or to accept a bill of exchange drawn of the beneficiary and pay at majority provide the specified documentary are duly tendered and any other terms and condition of the credits are combined with the contract arising of a documentary credits transaction. A documentary credits transaction is held together by a series of the interrecommended the contractual relationship. Firstly, there is a underlying sales contract between the sellers and buyer. Secondary, with the issuing bank agree of the amount, the instruction of the buying. A contract comes to